Today, we're really jumping into the deep end. We've got this huge stack of legal sources, the kind of dense stuff lawyers grapple with daily. And our mission, really, is to fast-track your understanding of some pretty advanced C2-level legal vocabulary and strategy.
Right, and we're not doing it with flashcards or, boring lists.
No, absolutely not. We're taking a shortcut by embedding ourselves right in the middle of a real-world high-stakes scenario. We're following one specific case, Vance versus Vance.
Ah, yes, a classic contested divorce. Messy, complex, and perfect for seeing legal language under pressure.
Exactly. It's emotionally charged, which, as you said, really tests the limits of legal terminology. We get to see how these abstract concepts actually play out.
It throws the core tension into sharp relief, doesn't it? The clash between letting people make their own agreements, freedom of contract, and the law stepping in to protect people when things seem fundamentally unfair.
That's the absolute crux of Vance v. Vance. We're watching Mark Vance, the defendant, being defended by his legal team. And part of that team is Madison, a super sharp law intern who's really trying to prove herself here.
A tough first case for an intern.
Definitely. Mark's wife, Sophia, and her lawyers are going after him hard. It's turned into this really bitter litigation.
In litigation, just to be clear for everyone, that's the whole formal process, right? The lawsuits, the court filings, the arguments, the whole shebang.
The whole shebang. And Sophia's main goal right now, to overturn a ruling. There was a previous decision that said their post-nuptial agreement was valid.
The post-up. Always a flashpoint. So they're trying to undo that prior decision. How?
They're hitting it with two very heavy legal terms. They're claiming the agreement is unconscionable.
Okay, that's a big one.
And they're arguing Sophia only signed it because she was under duress.
Unconscionable and duress. Yeah, those are the nuclear options in contract challenges. These aren't just like casual terms for unfair or I felt pressured, are they?
Not at all. In court, these words have incredibly specific and, frankly, very high thresholds.
Absolutely. Let's break that down a bit. Litigation, as we said, is the overall process. But the actual fight here hinges on unconscionable and duress. For a court to say a contract is unconscionable, well, the standard is often described as something that shocks the conscience of the court.
Shocks the conscience?
Yeah.
Wow. So it's not just a bad deal for Sophia. It has to be outrageously one-sided or unfair.
Exactly. It's really a measure of last resort. Courts generally break it down into two parts. There's procedural unconscionability, looking at how the agreement was made. Was there hidden language, unequal bargaining power? Did someone not have a real choice?
Yes, the process itself was flawed.
Right. And then there's substantive unconscionability, looking at the actual terms. Are they just incredibly harsh, oppressive, totally one-sided? Usually you need a good measure of both to convince a judge to throw out a contract. Sophia's team seems to be leaning heavily on the procedural side, arguing the circumstances of the signing made the terms unfair.
Which leads directly to the claim of duress. That's the spearhead of their procedural attack, isn't it? Suggesting her signature wasn't truly voluntary.
Precisely. Duress means her will was basically overcome by some kind of coercion or threat. It requires proving there was unlawful pressure.
Unlawful pressure. Like what specifically?
It could be threats of physical harm, sure, but more often in these cases, it might be serious economic threats, threats of unfounded lawsuits, or other wrongful acts that leave the person with no reasonable alternative but to sign.
No reasonable alternative. That's a key phrase.
It is. If Sophia's lawyers just show she was, stressed out, upset, maybe worried about money, that's probably not enough. Madison's defense will argue that's just the reality of negotiation sometimes. They have to show Mark did something wrongful to force her hand.
And Madison's job is to counter this by grounding everything in due process. Sophia is essentially arguing the whole situation violated her basic right to fairness in how the contract was executed.
It forces the court into resolving this fundamental dichotomy. And a dichotomy is just that, a division between two opposing ideas. Here, it's freedom of contract versus legal protection.
The idea that adults should be free to make their own deals, even bad ones.
Versus the idea that the legal system has to ensure fairness, protect against coercion, guarantee due process. That means ensuring rights are respected, procedures are fair. Sophia's arguing her right to understand, to get advice, to freely choose was compromised. That's a due process argument about the contract itself.
So the judge's ruling on whether this contract is unconscionable or signed under duress basically decides which side of that dichotomy wins out in this specific case. That's a huge hill for Madison to climb.
A very huge hill. Defending a signed contract is usually the easier side, but these claims, if proven, are powerful.
Okay, so Madison and her supervising attorney, Ms. Reyes, can't just rely on saying Mark's a good guy or Sophia seems emotional. They need a defense built on solid legal ground.
Absolutely. They have to navigate the rules of the game, the established legal framework. Before even getting deep into the duress specifics, they need to be crystal clear on the hierarchy of rules that govern this whole situation.
Hierarchy.
Yeah.
You mean like what rules trump other rules?
Exactly. It's not just a jumble of laws. Think of it like layers. At the very top, you have the broad concept of the law itself, the whole system.
Okay, the big picture.
Right under that, you have the Constitution, the fundamental principles, guaranteeing rights like due process, setting up the government's powers. If the post-up somehow violated a constitutional right, that would be a major issue. But usually, divorce cases operate at a level below that.
So where does the specific law about divorce or contracts come in?
That brings us down to legislation. These are the laws actually created by a government body, like a state legislature or Congress.
Stuff passed by politicians.
Essentially, yes. And within legislation, the key thing for Madison is the relevant statute. A statute is a specific written law passed by that legislature. There will be a state statute that governs divorce, marital property, and whether postnuptial agreements are even allowed, and under what conditions.
So that statute might say, for example, how property is normally divided in a divorce unless there's a valid agreement.
Precisely. The statute sets the default rules. For instance, is it a community property state where everything is split 50-50, or an equitable distribution state where it's split fairly, which might not be equal? Madison needs to know that statute inside and out.
And the postnup is basically Mark and Sophia's attempt to override that default statute, right?
Exactly. The agreement is the exception to the statutory rule. Madison's whole argument hinges on showing that this specific agreement is a valid exception, one that meets the requirements laid out in the statute itself.
Okay, so statute is key. What's below that? You mentioned regulations.
Right. Regulations are rules made by administrative agencies or authorities to implement the statutes. These can be super specific procedural things. Like the exact deadline to file a certain document, the font size required on court papers, how many copies you need, small stuff. But if Madison messes up a regulation, her argument could get thrown out purely on that technicality, even if the substance is strong.
Wow. Okay, so it's not just about the big legal ideas. It's about ticking all the procedural boxes too.
Yeah.
Which is all part of the litigation process itself.
The entire messy, complex litigation process. And, even though this is a civil case, a dispute between private parties, it borrows some procedural steps you might recognize from criminal law.
Like what?
Well, when Sophia first filed her claim trying to void the contract, Mark had to respond formally. That response is essentially his plea.
Okay, but he's not pleading guilty or not guilty.
No. In this context, his plea is his formal answer denying Sophia's claims of duress and unconscionability and asserting that the contract is valid and should be enforced.
Got it. And is there something like an arraignment where the claims are formally read out?
There's a similar function, yeah. Early hearings where the claims and defenses are officially put on the court record, the issues are defined. It basically sets the stage for the legal battle to come. It formalizes what exactly they're fighting about.
And speaking of the fight, let's be super clear on the players again. Sophia started the lawsuit to challenge the contract.
So she is the plaintiff.
And Mark, who's defending the contract's validity.
He's the defendant.
Represented by Madison and Mrs. Reyes, who are his lawyers or attorneys.
Correct. And they're presenting their case to the judge who makes the rulings.
And crucially, there's no prosecutor involved here, right?
Yeah.
Because it's not a crime.
Absolutely crucial distinction. A prosecutor represents the state in criminal cases. This is a private dispute about a contract, the division of marital property, and who bears the financial liability.
So Madison's immediate job is to use the state statute, the one allowing postnups, to show the judge why this particular contract should be respected despite Sophia's claims.
Yes, and she needs to show it complies with any specific requirements in that statute. For example, did the statute require full financial disclosure? Did it require the opportunity to consult independent counsel? Madison needs to demonstrate that those statutory conditions were met.
It's interesting. She's kind of using the law itself, the statute, to defend the contract against an attack based on fairness principles like unconscionability.
That's a great way to put it. She's arguing that the legislature already considered fairness when they wrote the statute allowing these agreements, likely because they valued certainty and the freedom to contract in personal affairs. Madison needs to remind the judge of that underlying policy.
So the judge isn't just reading the words of the statute, they're considering the why behind it too.
A good judge always does. They're applying both the letter and the spirit of the legislation. Okay, so Madison's laid the groundwork with the basic rules. Now, the defense strategy shifts to building legitimacy. First, they have to prove this court even has the authority to hear the case.
Right, that's jurisdiction, isn't it? The court's power to decide.
Exactly. Jurisdiction is fundamental. It's the court's official power to make legal decisions and judgments in this specific matter. Without it, anything the court does is basically meaningless, legally speaking.
So if Sophia's lawyers thought they could challenge jurisdiction, that would be their first move, to try and get the case thrown out before it even starts.
Potentially, yes. It's something Madison needs to be ready for. If there's any question about jurisdiction, she needs to shut that down fast.
Why would jurisdiction even be an issue in a divorce like Vance v. Vance? You said they live in the same city. Seems straightforward.
It often seems straightforward, but it can get tricky. There are different types. First, subject matter jurisdiction. Is this the right kind of court? Like, you wouldn't take a divorce case to traffic court. That's usually simple here. Family court handles divorces.
Okay, makes sense.
But then there's personal jurisdiction. Does the court have authority over Mark and Sophia personally? This often ties into residency. Most states have laws, statutes, saying you have to live there for a certain period, maybe 6 months or a year, before their courts can grant a divorce.
So if Mark or Sophia had just moved there recently, the court might not have jurisdiction over the marriage itself yet.
Correct. Madison needs to confirm they meet the residency requirements of the state statute.
What about their stuff, their property?
Yeah.
Does jurisdiction affect that too?
Oh, absolutely. This is where it gets potentially complex, especially if they own property outside the state. Let's say the Vances own a vacation condo in Florida, but the divorce is happening in New York.
Okay.
The New York court might not have what's called in rem jurisdiction over the condo itself. It can order Mark and Sophia, over whom it does have personal jurisdiction, to sell the condo and split the proceeds. But enforcing that might require coordination with Florida courts. Madison needs to make sure the New York court's orders can effectively cover all their significant property wherever it is.
Right, to avoid having separate legal battles in different states later on.
Yeah.
That sounds like a nightmare.
A very expensive nightmare. So nailing down jurisdictions over both the people and the property is step one.
Okay, so let's assume Madison confirms jurisdiction. What's the next big strategic pillar for defending the postnup?
History. Legal history, that is. She needs to find support in past court decisions. This is all about precedent.
Precedent. I've heard that term a lot. It's basically how judges decided similar cases in the past.
Exactly. Precedent is the absolute cornerstone of common law systems, like the one in the U.S. It refers to a past court ruling, usually from a higher court, that serves as a binding or persuasive guide for current judges facing similar facts or legal questions.
Binding or persuasive? What's the difference?
A binding precedent is one from a higher court in the same jurisdiction the current judge must follow it. Persuasive precedent might come from courts in other states or lower courts or even academic writing. The judge can consider it but doesn't have to follow it. Madison is looking for binding precedent if possible.
So the judge isn't just making it up as they go along. They're constrained by these past rulings. There's a principle for that, right?
Yes, stare decisis. It's Latin for to stand by things decided. It promotes predictability and stability in the law.
So Madison's job is to dig through case law and find a precedent where, say, a wife claims she was pressured into signing a postnup because she was financially stressed, but the court said, nope, that's not legal duress, and decided to uphold the verdict, meaning they kept the original contract valid.
That's exactly what she needs. Let's imagine she finds a case, maybe Johnson v. Johnson from the state appeals court, that explicitly states emotional distress or financial pressure alone isn't enough to constitute duress for voiding a postnup. That precedent is gold for her.
Because then she can argue to the judge, Your Honor, the higher court has already ruled on this exact type of situation. Sophia's claims, even if true, don't meet the legal standard established in Johnson.
Precisely. It shifts the argument from poor Sophia to this is what the established law says. It takes the emotional wind out of the plaintiff's sails, ideally. She's using history as a shield.
Okay, so precedent is key. Now let's talk about defending the contract itself, the actual document. Madison needs to highlight the specific terms that show it was a negotiated deal, right? She'd focus on the stipulations.
Yes. A stipulation in this context is a formal term for a specific condition, requirement, or promise laid out in the agreement. It's not just a suggestion. It's a key part of the bargain.
Can you give an example from the Vance case?
Sure. Madison might point to a stipulation in the postnup where Mark agreed to pay for Sophia's MBA tuition for 3 years, even if they divorced, in exchange for her agreeing to limit her claim on his future business earnings.
Ah, so that shows a give and take. She gave up something, but she also got something specific and valuable in return.
Exactly. Highlighting those bargain for stipulations demonstrates consideration, the legal term for something of value exchanged, and makes the contract look much less like a one-sided imposition, undermining the unconscionable claim.
That makes sense. Now, this whole court battle, it's happening because they couldn't agree beforehand, right? This is different from reaching a settlement.
Completely different. A settlement is an agreement the parties reach themselves, usually with lawyers' help, to resolve the dispute outside of a final court ruling. It avoids the risk and expense of a trial.
But here, because Sophia is actively attacking the validity of the existing postnup, they can't just settle based on it. They need the judge to rule.
Correct. They need a definitive verdict. A verdict is the court's final decision on the disputed issues after hearing the evidence and arguments. Madison is pushing for a verdict that says the contract is valid and enforceable.
Okay. And because this whole thing revolves around a contract, the postnup, what other related legal concepts might come up regarding Mark's potential financial obligations?
Well, if Mark had failed to follow through on his promises in the contract, like if he'd stopped paying Sophia's tuition as stipulated, she could have sued him for breach of contract.
Okay, breaking the agreement.
Right. And the whole point of this current litigation is ultimately to determine Mark's liability. That's his legal responsibility, particularly his financial responsibility regarding the division of their marital property.
So if Madison wins and the contract is upheld,
then Mark's liability is limited to whatever the stipulations in that contract say about property division.
but if Sophia wins and the contract gets thrown out,
Then insane liability could be much greater, determined by the default state statute on property division, which might give Sophia a much larger share of the assets.
wow. So getting the judge to accept the precedent Madison finds and getting the judge to enforce the stipulations of the contract directly impacts the final verdict on Mark's financial liability regarding their property. It's all incredibly interconnected.
Every piece matters in building the case.
All right, we've got the rules, we've got the strategy with jurisdiction and precedent. Now we're in the thick of it, the trial phase. This is where the actual evidence comes out.
And this is where things get really dynamic. Sophia's team will be trying to use testimony, maybe documents, to prove her claims of duress and unconscionability. Madison has to manage that incoming fire and launch her own procedural attacks.
Okay, first things first. Who has to prove what? That's the burden of proof, right?
Exactly. The burden of proof is the obligation on a party to provide enough evidence to support their claims. In a civil case like this, the initial burden is on the plaintiff, the one bringing the claim.
So Sophia has the burden of proof to convince the judge that duress actually happened and the contract is unconscionable.
That's right. She has to produce the evidence. The standard isn't beyond a reasonable doubt. Like in criminal cases, it's usually preponderance of the evidence.
Preponderance, meaning?
Meaning she just has to show that it's more likely than not, think 51%, that her version of events is true. It sounds like a lower bar, but when you're trying to undo a signed legal document, it's still a significant hurdle.
Okay, so Sophia carries the initial burden. What's Madison's goal then regarding evidence?
Madison's job is to substantiate Mark's defense. To substantiate means to provide proof, to back up a claim with solid evidence.
So she needs evidence showing the contract was fair and entered into willingly.
Precisely. She needs to introduce documentary evidence, things like emails showing negotiation back and forth, draft versions of the contract that Sophia reviewed, maybe even proof that Sophia had her own lawyer look at it before signing.
Showing she had independent counsel would be huge against a duress claim.
Absolutely. That kind of evidence helps substantiate the argument that this was an arm's-length transaction, not some ambush where Mark forced her to sign under pressure. It directly counters the narrative Sophia's trying to build.
Now, Sophia's case probably relies a lot on her own testimony, right? Her formal statements in court about what happened and how she felt, maybe testimony from friends or family too.
Very likely. Emotional accounts can be powerful. But this is where Madison needs to be incredibly sharp on the rules of evidence, especially regarding hearsay.
Hearsay. Okay, I know this is a big deal in legal dramas. What exactly is it in this context?
Hearsay is basically an out-of-court statement offered in court to prove the truth of what that statement asserts. The key problem is that the person who originally made the statement isn't the one testifying now.
Can you give an example related to the Vances?
Sure. Let's say Sophia's sister takes the stand and says, Sophia called me right after signing the papers, crying, and said, Mark threatened to ruin my reputation if I didn't sign.
Got it.
The sister is testifying about what Sophia said happened, the threat, but Sophia is the one who supposedly heard the threat, not the sister. The sister's testimony about what Sophia said is being offered to prove that Mark actually made that threat. That's hearsay.
And why is that generally not allowed?
Because the other side, Madison can't cross-examine the original speaker, Sophia, about the context of her statement to her sister, or, more importantly, the person whose statement is really at issue, Mark, about whether he actually made the threat. It's considered unreliable.
So Madison needs to be ready to jump up and object.
Instantly. Objection, Your Honor, calls for hearsay. If the judge agrees, that testimony is ruled inadmissible.
Inadmissible, meaning the judge cannot legally consider it when making the final decision.
Correct. It's struck from the record, essentially. Successfully objecting to hearsay can gut the emotional core of the opposing case, piece by piece.
Okay, that's a defensive move. What if Madison needs to get evidence from Sophia or a third party who isn't cooperating? Say, Sophia's therapy records that might show she was stressed for other reasons, not just Mark.
Then Madison uses the court's power through a subpoena. A subpoena is a formal court order compelling someone to do something.
Like show up in court.
Yes, a subpoena ad testificandum compels a witness to appear and testify. But more relevant here might be a subpoena ducis tecum.
Ducis tecum. Latin again.
It means bring with you. It compels the person or entity like a bank or maybe Sophia herself to produce specific documents or records. Financial statements, emails, appointment logs, whatever is relevant and specified.
So Madison can use a subpoena to force the production of evidence that could substantiate Mark's defense.
Yes, within legal limits, of course. You can't go on a pure fishing expedition. But it's a powerful tool to get necessary information.
And finding out what information to even ask for requires work before the trial, right? Who does that?
That often falls to an investigator. Law firms frequently use investigators to dig into facts, locate potential witnesses, verify statements, maybe find evidence that contradicts a claim. For instance, an investigator might find proof Sophia was actually on vacation and seemed relaxed around the time she claimed she was under intense duress from Mark.
That could be crucial evidence. It sounds like a whole team effort behind the scenes.
Absolutely. And in the courtroom itself, during the trial, there are key personnel making the whole process function.
Besides the lawyers and the judge, who else is critical?
Well, you absolutely need the court reporter. They're creating the official word-for-word transcript of everything said, every question, every objection, every ruling.
That transcript is vital, especially if there's an appeal later.
Indispensable. It's the official record of what happened. The court reporter also marks all the exhibits, the documents, and physical evidence introduced via subpoena or otherwise.
Okay, who else?
You have the bailiff, who is responsible for courtroom security and order, often acting as the judge's right hand for logistics. And then there's the clerk of court.
What does the clerk do?
The clerk is the court's administrative hub. They handle all the filings, manage the official case records, schedule hearings, and importantly, they administer the oath to each witness before they give testimony. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Got it. So lawyers, judge, reporter, bailiff, clerk, all working together. But ultimately, the judge holds a lot of power during this phase, right? More than just ruling on objections.
Immense power. We talked about ruling evidence like hearsay inadmissible. But the judge can also control the entire flow of the trial. And crucially, if Madison presents a strong enough case early on, or if Sophia's evidence is incredibly weak, Madison might make a motion asking the judge to dismiss outright Sophia's claim.
To dismiss outright, just end it.
Yes. If the judge agrees that even taking Sophia's presented evidence in the most favorable light, she still hasn't met her legal burden of proof for duress or unconscionability as a matter of law, the judge can grant a motion and dismiss the case then and there. Mark wins without needing a full verdict after all testimony. That's a huge procedural victory.
Wow. Okay, the stakes are incredibly high at every step. So let's fast forward. Imagine the evidence is all in. Madison and Mrs. Reyes are now preparing their closing arguments. This is their last chance to persuade the judge.
Exactly. This is where they weave everything together, the facts, the evidence, the precedent, the rebuttal of Sophia's claims into one final, compelling narrative. And the language here becomes incredibly important. We're talking sophisticated, precise legal phrasing.
This is where that C2 level vocabulary really comes into play, not just defining terms, but using them strategically.
Absolutely. It's about structuring the argument effectively. Let's look at 3 powerful connectors or function words Madison might use to frame her conclusion and manage potentially damaging facts.
Okay, first up, caveat. Sounds like warning.
It basically is. A caveat is a warning, a proviso, a specific stipulation added to qualify a broader statement. It's a way to acknowledge a point but limit its impact.
How would Madison use it here? Sophia's team probably painted Mark as wealthy and powerful, contributing to the pressure argument.
Right, so Madison might say something like, Your Honor, while the plaintiff has emphasized the disparity in the parties' financial resources, and we acknowledge that disparity existed, there is a critical caveat. Financial inequality alone does not constitute legal duress. The precedent in this jurisdiction is clear that more is required, specifically wrongful conduct, which the plaintiff has failed to substantiate.
So she acknowledges the fact, the wealth gap, but adds the caveat that it's legally irrelevant to the duress claim without proof of wrongdoing. Very neat.
It neutralizes the point without seeming dismissive.
Okay, next power word. Notwithstanding. This one sounds quite formal.
It is, and it's very useful. Notwithstanding essentially means in spite of or nevertheless. It's perfect for transitioning from a point you concede or acknowledge the other side made back to your main argument.
How would that work in the closing? Maybe addressing Sophia's own testimony about feeling pressured.
Exactly. Madison could argue. Notwithstanding the plaintiff's sincere testimony about her emotional distress at the time of signing, the objective evidence, the email records, the multiple draft reviews, the involvement of her own counsel demonstrates a lengthy negotiation period. Her subjective feelings, notwithstanding their sincerity, cannot overcome the documented proof that she had ample opportunity to understand and reject the agreement.
So, yes, she felt bad, but look at the actual proof. It isolates the legal argument from the emotion.
Precisely. It pivots back to the strength of her case, the documented evidence.
And the final one, hence, the sound of logic.
Hence is used to signal a logical conclusion or deduction based on the preceding points. It tells the judge, based on everything I've just shown you, this is the inevitable legal result.
So this would be right at the end of her closing argument.
Ideally, yes. The final punch. She might summarize. The plaintiff failed to meet her burden of proof on both duress and unconscionability. The evidence presented overwhelmingly substantiates that the contract was negotiated fairly and with independent counsel. The terms, while perhaps not ideal in hindsight, do not shock the conscience. Hence, this court must deny the plaintiff's claim, uphold the verdict validating the postnuptial agreement, and rule in favor of the defendant.
Powerful stuff. It connects all the dots and leads the judge directly to the desired outcome. Okay, so let's say Madison wins. The judge issues a verdict upholding the contract. What happens next? What kind of language describes the resolution?
Well, the parties have to live with the ruling. Sometimes, to achieve finality, one party might agree to waive certain rights they might technically have.
To waive, meaning to give up a right.
Voluntarily relinquish it, yes. For example, the postnup might entitle Mark to reimbursement for some costs. He might technically have the right to pursue Sophia for those funds, but to just end the conflict, his lawyer might advise him to waive that right, sign a document saying he won't pursue it.
Okay, that makes sense for closure. What if this case had gone up on appeal to, say, the state Supreme Court? The judges there are called justices, right?
Correct. At the highest state or federal levels, judges are often called justices.
And if multiple justices hear the case, they might not all agree completely on the reasoning, even if they agree on the outcome.
That happens frequently. One justice writes the main opinion. Others might write separate opinions where they concur with the result. To concur means to agree with the final judgment, but perhaps for slightly different legal reasons, which they'll explain in their concurring opinion.
And the final decision, whether from the trial judge or the justices, sets out the ramification.
Yes, the ramifications. These are the consequences, the far-reaching effects of the ruling.
What are the ramifications in Vance v. Vance if Madison wins?
The ramifications are huge. It means the postnuptial agreement stands. It dictates exactly how their marital property is divided. It defines Mark's final financial liability. For Sophia, the ramifications are that she's bound by the deal she signed, her challenge failed, and she gets whatever the contract provided. not what the default state statute might have given her. These consequences are real, financial, and long-lasting.
It really underscores the power of these legal processes. Let's zoom out a bit and think about the people involved in making this happen. Madison, our intern, hopes to become an associate attorney. How does that differ from her supervising lawyer, Mrs. Reyes, who's likely a partner?
Big difference in status and responsibility. An associate attorney is usually a younger lawyer employed by the firm, typically paid a salary, works long hours, and executes strategies often set by senior lawyers. They're building their skills and reputation.
Have a partner.
A partner is a senior attorney who has an ownership stake in the firm. They share in the profits, help manage the firm, bring in clients, and have ultimate responsibility and liability for the cases they oversee. Mrs. Reyes, as the partner, is guiding Madison and carries the final weight.
And we talked about the prosecutor distinction earlier. They handle criminal cases for the state.
Oh.
Madison and Mrs. Reyes are civil attorneys.
Correct. Representing private clients in disputes.
And their success heavily relies on those support roles too, right?
Absolutely essential. We mentioned the investigator. Think also about the paralegal. A good paralegal is invaluable. They likely did a huge amount of work organizing all the evidence, drafting initial versions of motions and filings, managing deadlines, preparing exhibits for trial.
And the legal researcher.
Yeah.
The one who actually found that crucial Johnson v. Johnson precedent.
Exactly. Often, it's a dedicated legal researcher, or maybe a junior associate or paralegal, tasked with spending hours sifting through databases to find the case law that perfectly supports the argument. It's detailed, painstaking work, but finding the right precedent can win the case.
It really is a team sport.
Yeah.
Okay, one last area. What if Mark and Sophia had looked at this whole messy public trial process and thought, there has to be another way?
There often is. Alternative dispute resolution, or ADR. It's increasingly common, especially in sensitive cases like divorce.
What are the main options?
Two big ones are mediation and arbitration. A mediator is a neutral third party, trained in negotiation, who tries to help Mark and Sophia reach their own voluntary settlement. The mediator doesn't impose a decision, they facilitate communication and explore options.
So it's non-binding. They can walk away if it doesn't work?
Typically, yes. The goal is a mutually agreed upon settlement. If they reach one, it becomes a binding contract. If not, they can still proceed to court.
What's the other main ADR option?
Arbitration. This is more like a private trial. An arbitrator, often a retired judge or an experienced attorney with expertise in the area, acts like a judge. Both sides present their evidence and arguments, usually less formally than in court.
And the arbitrator makes a decision.
Yes. The arbitrator issues a binding decision, an award, which functions much like a court verdict. It's generally final and enforceable. The key benefits are usually speed, lower cost compared to full litigation, and privacy. The proceedings aren't public record.
So if the Vances had prioritized confidentiality and a faster, definitive answer above all else, they might have chosen an arbitrator instead of battling it out in court.
Very possibly. They would trade the possibility of appeal, which is very limited in arbitration, for finality and privacy.
Well, that brings us to the end of our deep dive into the world of Vance v. Vance. We've followed Madison's journey defending her client against these heavy claims, and in doing so, we've really unpacked some complex C2-level legal language in context.
It wasn't just about defining words like unconscionable or duress. It was about seeing the incredible high bar needed to prove those claims, how they interact with fundamental principles like due process, and that constant tension between freedom of contract and legal protection.
We saw the strategic importance of nailing down jurisdiction, the power of finding the right precedent to counter emotional arguments, and how the burden of proof dictates the flow of the litigation.
Yeah. Mm-hmm. And we saw how procedural tools, like objecting to hearsay to render testimony inadmissible, or using a subpoena to get crucial evidence, are just as important as the substantive arguments.
Plus, we got a feel for those sophisticated connectors, using a caveat strategically, pivoting with notwithstanding, concluding logically with hence. That's the kind of precise language needed to really navigate these complex legal waters.
And hopefully, for you listening, this journey through one case helps illustrate how these mechanisms, the statutes, the precedent, the rules of evidence really govern law in daily life, especially when it comes to contracts, property, and financial liability.
It really shows how this formal system tries to impose order and find certainty, even in the most chaotic and emotional human situations, like a divorce.
Which leaves us with a final thought to chew on. How effective is a system built on the certainty of procedures like due process and the weight of history found in precedent at truly resolving something as messy, subjective, and emotionally charged as a contested divorce?
That's a deep question.
And when that final verdict lands or the arbitrator's award is issued, what are the real lived ramifications for people like Mark and Sophia? Beyond the division of property on paper, how does that legally defined liability reshape their futures? Thinking about that gap between legal ruling and human reality really shows you the profound power and perhaps the limits of legal language.